So welcome all at the particular times that you're tuning in to this program. We will shortly turn to our program on governing U.S.-China trade relations with two eminent experts on that. But as usual, I want to tee up our forthcoming events. So I'm Jose Alvarez. I'm faculty director of the U.S. Asia Law Institute at NYU School of Law. And as many of you know who've been tuning into these events, we do these on Wednesdays. Typically, we vary the time depending on the availability of our speakers, but we are conscious of the fact that people may be tuning in, not just to the East Coast of the US, from other parts of the world. So next Wednesday, November 17th, starting at 6 p.m. and going for only 60 minutes because it is part of our US-Japan Short Takes program. We'll have a very special program called Lawyering the Olympics with two of the top lawyers involved on one side in the Tokyo Olympic Committee that arranged the Tokyo Games, and on the other side, the lead counsel for the largest team delegation that was sent, over 1,200 athletes from the United States. So tune in. That event is on our website. You should always send in the RSVP so you get the automatic Zoom. That's Lawyering the Olympics on November 17th from 6 to 7. Following that event, and this is unusual for us to do two things at a time, but we are attempting this. Immediately following, starting at 7 to 8:15, we have a diplomacy strategy and force managing rising tensions in Taiwan, which addresses the risk of military conflict and options to avoid that. Basically, what are ways to keep peace in the Taiwan Strait? We'll have three eminent experts in the field, and our moderator is the incomparable Jerry Cohen. So please tune in to that. That's next Wednesday from 7 to 8:15. So today's event is, again, focusing on US-China, but this time squarely on trade. And I couldn't be more pleased with the two people that we've managed to drag out for this. So Greg Shaffer is Chancellor's Professor of Law and Political Science. He's the Director of the Center on Globalization, Law and Society at the University of California, Irvine School of Law. He is President-elect of the American Society of International Law and will assume the reins of that society in April, I believe, of this year. He's a member of the Board of Editors of the American Journal and the Journal of International Economic Law. His recent books include Emerging Powers in the World Trade System, The Past and Future of International Economic Law. And he'll be addressing an article that is in the current issue, can't be more timely, of the American Journal of International Law. Those of you who only downloaded on the web should know it actually physically exists. This is what the thing looks like. And the title of his article is Governing the Interface of US-China Trade Relations. There is a link to his article as published in the journal right on the announcement of today's program. Greg's commentator is Chantal Thomas, the Radis Family Professor of Law and the Associate Dean of Academic Affairs at the Cornell University School of Law. She's truly an eminent commentator, especially, but not only, on trade law. Her recent publications include Race as Technology of Global Economic Governance in the UCLA Law Review, The Contested Boundaries of International Migration Law in the Post-Pandemic, and she's writing a book on the very subject of migration. She is also a member of the U.S. State Department's Advisory Council on International Law. The way we proceed with this, Greg, you'll go first, describe what you say in the book, and then Chantal will tear you apart. So you go ahead, Greg. I'll get off right now.
Great. Thank you, Jose. And welcome. Hello, everyone. So let me just give a little bit of a background on this article, Governing the Interface of US-China Trade Relations. And then I'll share my screens because it's a very long article and it's obviously a huge topic. And so I'll try to simplify it, the argument, and then I can have a conversation with Chantal, which I greatly look forward to. So first, just in terms of this article, the clearly there's a, China seems to be the focus in talking about trade today. And there was a symposium, and I was asked to contribute, and I was just finishing up my book, Emerging Powers in the World Trading System, of which China clearly is a central part. And I was asked to do something sort of thinking forward about how to govern this relationship. And I came up with the idea that, one way to think about it is through the different aspects of this relationship. And I typologized it into three aspects. One is sort of how we see with respect to China and the US in certain ways, a clash of capitalisms. And so the US has a vision of what capitalism entails, which is a much more market-based approach. And China's form of state capitalism is in stark tension with the US model. And so you see calls for how to rein in China's economic model, or at least to create an interface between the two economic systems through common trade rules. A second is the rise of geopolitics and national security concerns, particularly with respect to the growth of the digital economy, and so the commanding heights for the future in terms of companies which are based and rely on sort of this new forms of high technology. And what does this then pose for the relationship between these? What sort of rules can govern this relationship, especially during the Trump administration when you had the national security card being raised over and over again? And so you have a sort of a clash of power. Can we address this actually through multilateral rules or bilateral trade rules? And the third is this concern over values and the clash of values, labor rights, and so forth. How should we be thinking about the relationship in these terms, especially with the Biden administration now with its, quote, worker-centered trade policy? How do we think about this? And so I'm going to share my screen now, sort of address these three different issues. One second, just to move, there we go. And so it's very dramatic, but I think it actually captures some of the tensions in Geneva. Really, countries are caught between this sort of clash of US, China, and the rest of the trading system, in a sense, is being held hostage to this conflict. And so as you see, in terms of these interfaces, the article really can be viewed as sort of sets up the argument, and then a bulk of the piece, parts 3, 4, and 5, respectively address US critiques and of China's state capitalism, use of state-owned enterprises, state subsidies, industrial policy, and so forth. The part 4 then addresses this geopolitical national security interface, concerns over China broadly as a rising power, bolstered by China's economic success in competing for the very commanding heights of innovation. Concerns regarding Chinese infiltration of infrastructure, such as through 5G technology, data gathering, and other forms of leverage that China is now able to exercise. And third is the normative or social policy interface, reactions to China's authoritarianism and human rights and labor practices, which indirectly implicate workers, consumers, and the social bargain in the United States through imports and consumption. Okay, so this article builds off of, which is much more of a positive account of the sort of new situation sense in which we now reside. Situation sense actually comes out of the legal, is a quote from Carl Llewellyn, a famous legal realist in the 1930s. My approach to thinking about international law and trade law generally is a legal realist conception. And this is the cover of the book. Where are we now that you see with China's rise, coupled by those of India and other emerging powers? what's the future of international economic law? And part of what the book does is it links the what's happening at the domestic level to what's happening at the international level and vice versa. So it examines the major impact actually that the WTO had on China, Brazil, and India internally in terms of their laws, their regulations, their institutions, their professions, the organization of professions, including and in particular regarding trade law, the rise of mega law firms. And so it examines how China, India, and Brazil were able to take on the United States, go lawyer to lawyer, case by case. And so the United States and Europe were no longer really dominant in the trading system. This sort of rise of China had an impact in the United States itself, which we see, really culminated in a sense in the election of President Donald Trump. And I break this down into sort of a double-edged shift in inequality. Trade simultaneously helped reduce inequality between countries because of higher economic growth rates in Asia and the rise of middle class in China and India. And so you see this in terms of just major shifts in global GDP, so that, or national GDP, comparative GDP, so that China sort of is bound to, it looks like it's going to surpass the United States within a decade. It already has surpassed the United States in terms of gross domestic product when measured by purchasing power parity, the purchasing power of Chinese in China compared to the Americans in the United States. At the same time, it led to an increase in inequality within countries, and most starkly in the United States, so that inequality levels here are now back to what they were in the 1930s. And we know what this combination of shifts in inequality led to in the late 1930s and 1940s. And so we're in a sense back to the sort of potential chaos that the world was in the interwar period between World War I and World War II. And the potential challenge, or the ongoing challenge now to international institutions and their role. And even though, of course, the Biden administration said that policies were going to go back to the multilateral stage, America's back, as recently as we see now in the UK and Glasgow with respect to the climate change negotiations. But in trade, the United States, it's been carrying on, it's been carrying on basically the Trump administration's policies towards China. There's divisions apparently within the administration in terms of how to proceed, but the national security folks, National Security Council, appear to be very wary of any sort of significant shifts vis-a-vis the policy towards China regarding trade. And this is backed by just shifts in US popular perceptions of China, which have significantly shifted, in part perhaps because of the rhetoric with COVID-19, but also just the sort of the ongoing these shifts in inequality and sort of blaming China for many of what's the economic challenges in the United States today, much less everything else. So in big, broad terms, how do we even think about going forward? And so the article poses three broad-based approaches. One is just where we are now. The United States under the Trump administration ended binding WTO dispute settlement, and the Biden administration has not relaunched it. And so the result is we're no longer resolving disputes through a neutral third-party dispute settlement system, but rather through power-based bargaining. And the Trump administration felt that the US would be better off sort of in addressing China and everybody else in the world through just through an exercise of US power, And the question is, has this been successful, either in changing China or in for the United States in relationship to China generally? A second approach, which you see many sort of, I would call sort of the old mainstream of trade analysts, be it in economics or in law, or when they join together, law and economics, is that we need more rules to rein in China. And you hear this actually also both in the Trump administration and in the Biden administration, that the WTO simply, the current rules are insufficient. And we need more WTO multilateral legal constraints, and particularly on state-owned enterprises and on state subsidies. And this view is encapsulated very well in a new book by Professor Alvarez's former colleague Petros Mavroidis, who teamed up with a major European economist based in Brussels, Andrei Sapir, in which they call for more WTO legal constraints. And they say either China must adapt to these new rules, or the WTO simply will no longer be functional. And so they pose this as the alternative. And I argue in this article that I think that's a mistake. And so the rest of the article will explain why, and I'll put forth a third alternative. It could be viewed as a middle ground approach, which would be to recognize greater policy space along all three dimensions that I first noted, but with multilateral oversight and dispute settlement, that it would actually serve both the United States and the world's interests more to sort of actually move back from a neoliberal model and provide states with, the ability to modestly decouple from each other, where national security or major social policy or major economic concerns are at stake, but nonetheless retain a global trading system with multilateral oversight, which would be both in our and the world's interests. So this approach builds off of one that a group of Chinese and European, largely economists, but there were some lawyers as well, and I signed on to this. It was called Danny Roderick created this out of the Harvard Kennedy School. Justin Lee in China was a major part of this. And the idea was to create a working group to see, what sort of basic principles could govern the relationship. And then after, agreeing on principles, then we could flesh these out potentially with something more. And this article, in some ways, is a fleshing out of something more of these basic principles, but with some changes. So, because everybody had to compromise with respect to creating this working group framework. And so, first of all, just basic put all policies into 4 buckets. One was policies prescribed for their predatory nature, And of course, clearly the US views many of China's policies as being predatory, but US policies can be viewed as predatory as well. As we'll see, there's going to be a challenge to this, because from an economic perspective, it's easier to talk about predatory policies where you're trying to not so much protect yourself, but just harm the other, even while predatory pricing would be an example of sort of monopolization and so forth. And I'll give a couple examples of these type of policies, but they work less well when you're talking about national security concerns, because of the very idea of national security is you want to harm to disenable the other side to be able to develop certain types of weapons and so forth. Second, policy subject to bilateral negotiations. So you can see there's a shift towards saying that not everything's going to happen multilaterally in the WTO. There's got to be space within the multilateral framework for bilateral negotiations. And there already is, to a certain extent, but this clearly puts more science and prominence in today's world on bilateral negotiations. The third is providing where bilateral negotiations fail, providing for unilateral measures, but subject to a central principle in international law, which is proportionality, to ensure that they're proportionate responses. And then four, of course, in these bilateral relationships, there's going to be potential impacts on third parties. And so the fourth bucket are policies regulated through multilateral rules because of potential spillover effects from bilateral agreements on third parties. You can see this with respect to the phase one deal between the US and China. What are the implications of that for third parties? And to the extent it results in discrimination against third parties, what sort of rules would apply multilaterally? This article clearly expands categories 1 and 4 to retain much of what I view as the core principles in WTO law, which are principles of non-discrimination and transparency. So those go beyond, they include bucket 4 with respect to spillover effects from third parties, but they're also include, for example, not just what would be referred technically to the most favored nation clause, treating all countries equally, but also what's called national treatment, not discriminating against external products vis-a-vis your own through your regulatory or tax policy or otherwise. And so the key principles, though, of this, coming out of this, is that the need for policy space to respond to externalities, economic, national security, or regarding the basic social bargain within a country, and the proportionality of responses. Okay, so this is a lot on this slide, but let me the idea is to break this down into 3 interfaces. Note the concern, the problem. Note what self-protection now is available in terms of domestic regulation. What are the existing multilateral rules, and what sort of new rules might we imagine? So for the economic interface, you hear the rhetoric of China's cheating through its state-owned enterprise, through its subsidies. We have self-protection in the United States through different import relief regulations, raising tariffs. The existing rules permit these if they take one of 3 forms: anti-dumping law, countervailing duty law, safeguards law. And new rules could clarify the sort of policy space permitted by these rules, which I go into more detail in that section. National security interface. This is the question of how do we even conceptualize this, but we have national security regulations. You have a GATT Article 21, but it was adopted in 1948, clearly before the internet existed. And this being these sort of provisions you see being adapted in bilateral and plurilateral agreements to address cybersecurity and other concerns. Social policy interface, what are the risks to workers and the social bargain? We have concerns of, self-protection, we have potential social dumping regulations. This hasn't really been developed, but something I've been trying to, I've written earlier articles setting forth potential rules to address social dumping. And then of course, trade adjustment assistance for workers. We have existing rules. 20E in the GATT, this covers prison labor, but nothing else. 20A covers public morals, sort of very broad, but potentially covers forced labor, slavery, and other sort of gross human rights violations. And we could think about new rules on labor rights and mechanisms to counter abuse of social dumping regulations through plurilateral and bilateral agreements. We're seeing this being developed now. Outside of I live on the coast of California. Outside of my window now, I never saw container ships before because the harbors of Long Beach and Los Angeles are 40 miles away, but now we have container ships lining up to get in because of all the bottlenecks. My argument in this section is that the wrong approach is to constrain the state and industrial policy. There's a lot of we've seen a shift within the Biden administration, others sort of politically, that we need actually a greater role for the state to address challenges of COVID, pandemics, climate change, subsidizing semiconductors for national security reasons, and so forth. And so the idea that somehow we're going to have a third-party dispute settlement system, also addressing whether or not these are legitimate in the United States, that just seems mistaken to me. Countries, we may agree or disagree regarding the importance of industrial policy, but that's a choice. That's a national choice. So my preferred approach is not to create new international rules that cut off those choices, but rather to provide for greater policy space, in particular for safeguards, economic safeguards, which would then raise tariffs and potentially then permit a rebalancing of the trade relationship. The importance of transparency in governing state-owned enterprises, and I talk about this is a much better approach. The critique of state-owned enterprises is when you don't understand what sort of subsidies are being granted through state-owned enterprises. And so there's a role for creating presumptions with respect to them, unless policy is made much more transparent. And then potential tariff rebalancing. The WTO actually rules provide for potential not only negotiating lower tariffs, but also raising your tariffs, and sort of proportionate, and then other sides can proportionally raise their tariffs as well. So that's an option if one wants more of a buffer from the shocks of global trade. Forced technology transfer. This clearly is I put in quotes, because it's a major US concern when you set up joint ventures, and European concern in China, and then the joint venture partner takes the technology. This involves trading technology for market access and benefits. But this is a common developing country strategy, right? It's up to the firms to determine whether or not they want to form a joint venture and enter into that market. So I don't think that this would be it'd be a mistake, in my view, to cut off developing countries' ability to require joint ventures, generally through multilateral rules. This is much better area for bilateral negotiations with China. Governing the national security policy interface, the key issue is the conceptualization of what is security. So first of all, I just recognize that there's a spectrum. And I think it'd be mistaken to view everything as national security, because if that's the case, then I think we'll actually reduce security, because the sort of relationships and multilateralism will unravel. The second key aspect of this is what is a proportionate response, and I try to flesh this out by giving examples of Huawei and TikTok. For Huawei, it clearly, to the extent is building 5G infrastructure, which can be fragile, which could be, basic communications network system in the United States. There's a clear security rationale for prohibiting use of Huawei equipment. Although even there, that decision-making could be much more transparent than it has been in the United States. With respect to TikTok, Tesla, for example, in China, TikTok in the United States, it just seems that a forced sale to a US company by a Chinese company is a disproportionate response. If there's concerns about gathering data and so forth, there are different ways to address this. For example, in Tesla, what China did is it said that government officials and military officials can't travel in Tesla cars, but others can. And then boundary work, clearly this is going to require some boundary work. What is a national security issue versus an economic issue? How do we address this? And one way is to view national security as a form of a safeguard, which if you then raise barriers, the other side can raise proportionate barriers in return, resulting once more in a rebalancing of the relationship. And then normative social policy interface. Do we conceive of this as what's happening in other countries as a human rights or a social labor rights issue? Those are very different conceptualizations. Human rights is about individuals in relationship to the state, whereas labor rights are respect to collective organization of workers vis-a-vis capital. And so they're competing logics also. Is it a cosmopolitan logic wants to change other countries, wants to change China, for example. Whereas another logic, which is a logic I adopt, is that we don't want to be complicit in human rights or labor rights violations. And we want to protect our own social bargain from that. But that's a very different, less missionary role for the trade rules, which I believe is much more important. And we see this being developed in the US-Mexico-Canada agreement, the EU-Korea agreement. This is going to be happening in bilateral and plurilateral agreements. In terms of returning to dispute settlement, I put forth different options. I favor the first. It could be contingent on new procedures and substantive rules. I just put out an op-ed in The Hill last week as why this would be in the US interest, would be more effective in challenging China than the current situation of power-based bargaining. But one could imagine development of non-adjudicatory mechanisms, especially for national security issues, sort of more along an OECD type model of peer review, or a variable geometry, which is what we have basically with the International Court of Justice, where you can choose, through reciprocity, who you'll have binding dispute settlement system with and with whom you will not. So that's just to wrap up, basically, to save the world and the trading system from basically blowing up, one alternative is to simply provide for more policy space along these three dimensions. I hope that was helpful in setting it all out.
Thank you so much, Greg, for this really excellent paper. And I should also say thank you so much to the USALI and to Jose for inviting me to participate in this conversation. It's really wonderful to have the opportunity to see you all and to have the chance to participate in today's discussion on these incredibly important and timely issues. So Jose asked me to give a few moments of comments. So I'll give a few moments of comments to open up our conversation. And I also encourage anyone with a question, a thought, a concern to please write it up in the Q&A, and I can pull those comments and questions into our conversation. And I very much look forward to hearing your views in the audience as well. So my comments are going to be pretty informal. I thought I'd begin by highlighting some of the paper's important contributions, and then continue by asking some questions, not so much about the paper's analysis or critiques of it per se, but more so questions about how to extend that analysis out to the many issues that we see populating today's world of international trade law and policy. So in terms of the highlights of the paper, this is a wonderfully rich paper, and Greg gave a fabulous overview of it just now. The paper offers so many insights and contributions. I want to highlight in particular the ways in which the paper's analysis is integrative, it's progressive while being pragmatic, and it's also quite agile. So that paper is integrative, both substantively and methodologically. Substantively, it represents a huge amount of synthesis of sometimes very complicated WTO law on subsidies, state-owned enterprises, forced technology transfer, and it lands with very helpful suggestions for how to advance and refine WTO law on those points. So I found myself largely agreeing, Greg, with your take on those issues. And that in and of itself, that substantive synthesis, I think provides a huge service to readers. Methodologically, the way in which the paper generates that analysis builds on Greg's earlier work on legal realism in international law, on transnational legal orders, and of course the new book, in insisting on acknowledging the reality that the international arena is not informed only by WTO law that centers on trade relations, but that it necessarily also functions along these other axes too, of national security and social policy. So the paper shows the utility of the multi-layered analytics that Greg has developed in his larger body of work for how these dimensions potentially relate to each other and for an integrative approach for understanding these issues. So that was for sure a highlight for me in reading the paper. The paper is also progressive while being very practical. So it's of course very much aligned with Danny Roderick's heterodox approach to international trade law that foregrounds the importance of policy space for WTO member states. And it builds on the foundational understanding that one size does not fit all in industrial policy and economic development policy. And here I think the paper pivots very usefully away from another sort of prevalent view that Greg was describing in international trade law and policy that wants to portray the trade regime as necessarily resting on a consensus around a particular liberal or neoliberal approach, what some folks have called embedded neoliberalism. And the paper is observing instead that the trade regime has always been informed by plural approaches to economic regulation, that plurality can be seen by looking at the history of the trade regime's approach to state-owned enterprises in particular. So that approach that plural approach by no means arose solely with the advent of the Chinese economic model. Here the analysis, I think, very helpfully it moves away from that assertion of a universal consensus WTO and towards an understanding that even though the GATT WTO has operated institutionally largely by consensus, that consensus has itself served as an interface across broadly varying approaches to trade. So I found it to be very helpful to create a little bit of space around that consensus view that otherwise could, even if inadvertently, wind up feeding into a kind of a reactionary view of the US-China trade relationship. So, and creating a little space here is very helpful, while at the same time recognizing that there are legitimate concerns. So in terms of grappling with those concerns, the paper is also looking to walk a very fine line, I think, in that it wants to adapt the approach of Roderick and his colleagues, in particular as reflected in the US-China Trade Policy Working Group's joint statement, which Greg and I both signed. And the adaptation of that joint statement is both to continue to emphasize the importance of policy space and flexibility, while also, I think, further emphasizing and centering the importance of a multilateral framework. And here, between the lines of the text, I certainly inferred an international trade lawyer's sensibility that the multilateral framework built up through the post-World War II era, with all of its flaws, has served as an essential bulwark for global stability, and it cannot and should not be lightly discarded. And so playing up the role of the multilateral framework is a further, I think, adaptation of the joint statement. But given the gravitational pull away from trade multilateralism in today's setting, how do we preserve that umbrella of multilateralism, as Greg calls it in the paper? And here, I think, is where the agility of the analysis comes into play. So Greg's approach, in addition to potentially reforming WTO dispute settlement in and of itself, also potentially allows for harvesting policy developments, for example, in bilateral and plurilateral agreements on national security issues, while also envisioning more policy space for unilateral movement on national security and social policy issues. And all of that sort of cabined by the essential normative and doctrinal constraints of WTO law. So this is very, very agilely kind of bumping up and down across categories and boxes in this multi-layered framework. And you could say, this is complicated for sure. And one could say, well, why would states bother with this? I mean, why would they work so hard to stay within the multilateral framework while also pursuing these bilateral and unilateral approaches? How can we maintain the gravitational pull towards multilateralism, continue to center it? And I think, again, here, that underlying sensibility around the shared benefit of the multilateral framework is why they would and why they should. That's implicit in the argument, that this is why at the same time that the multilateral framework for its part needs to adapt in turn in order to survive and in order to preserve itself and the larger ends for which it was designed. So not only prosperity, but also peace and stability. So those were some of the sort of highlights of the paper for me. Again, really a wonderfully rich analysis. And with those, I thought I would also present briefly some thoughts and questions. One around trade and social justice or social policy. One around implications for developing countries as a whole. And then one around the national security frame as a largely unilateral policy endeavor, which is how it's portrayed in the paper. So on trade and social policy, and we've had the discourse on linkage for some time on issues of labor and environment. You've done incredibly helpful work on developing a more precise approach for how to use trade remedies on social policy issues. Again, here, we're adapting the policy insights of Danny Roderick and other economists, and the proposals you make on safeguards in particular, I really think have become so well refined. I feel like they're ready to be road tested. So I don't know, Biden administration, if you're listening, but with the Biden administration's approach to trade, I could imagine seeing this potentially now, adapted in some form. And so I think that framework is very, very helpful and constructive. One question I had for you was whether you could elaborate a little bit more on how your framework relates to issues of climate change. And I'm asking this in particular because it's in the news this week. Scotland has been hosting the UN climate change conference. President Biden ended his time at the UN at the climate summit, chastising President Xi for physically skipping the event and for failing to make the level of commitments that other nations did, et cetera, et cetera. So your paper talks about climate change, and you note that border tax adjustments could be an example of a unilateral approach. And you know that there is a lot of literature on this. There certainly is of our colleagues in international trade law and elsewhere. But I guess I wanted to take the opportunity to ask you to elaborate a little bit more on how the climate change issue would fit into your framework, particularly in light of the increasing salience of these issues. A separate question, and here I'm going a little far afield, but I'm taking advantage of my speaker's prerogative. I'm just curious. Around how and whether your framework could relate or would relate to particular identity-based forms of structural equality and inequality. So we've seen international trade law and policy discourse and scholarship begin to delve into these issues in a way that I certainly never thought I would see in my lifetime. The WTO Joint Declaration on Trade and Women's Economic Empowerment from the 2017 Ministerial Conference being one example. And so it's stimulated a lot of scholarship, and you are organizing this upcoming symposium in Age-Old Unbound on international law and its others, which I think will be a really exciting moment to address those questions. Obviously, I'm not suggesting that the US-China trade relationship has to address issues of gender, race, and trade, and so on. But I'm curious about your frame for trade and social policy, which you developed elsewhere and applied to the US-China trade relationship. Do you see a role for that framework for these kinds of trade remedies to address these kinds of issues, or is that really a unilateral kind of national domestic conversation that each country needs to have for itself? Okay, so what's your broad set of questions, and please feel free to just take those as rhetorical, respond to any that you care to, ignore others. But I wanted to just bring these up for purposes of thinking about all the great insights in your paper. Another set of questions is around implications of your analysis for developing countries. So to be sure, your paper is centered on China and the US-China relationship, not so much directly on how developing country interests play into this. For sure, the US-China Trade Policy Working Group statement contemplates the issue of spillover effects on third parties, and your paper addresses those, broadly speaking. But I wanted to hear more from you on the question of the role of developing countries and how smaller economies are supposed to deal with this predicament. You noted at the beginning of your remarks here that the rest of the trading system has been held hostage, and we can imagine that smaller economies could be differently and disproportionately impacted by that in various ways. So you could imagine a beneficial effect. So some countries like Vietnam, some Latin American countries have benefited from trade diversion. The paper briefly references a kind of negative form of trade diversion where Chinese imports diverted to third country developing country markets could depress prices in those markets and then lead to an export advantage into the US. But it could be a more straightforward kind of beneficial trade diversion for those countries. It could be a negative impact, in particular, the focus on policy space, while it could open up flexibility, could also take away multilateral commitments, undermine multilateral commitments to development. And so here, I note that your paper seems to envision a largely unilateral approach to development. So open up policy space, and that allows developing countries to pursue their own models without the constraints of embedded neoliberalism. But historically, developing country governments have fought hard for a multilateral commitment to shoring up their national development policy efforts. And, it's been very, very fraught and probably, in many ways unsuccessful. So you could say, let's just shelve all of that, the efforts to elaborate a principle on special and differential treatment and so on. But, so how do developing country interests fit into this? What could be the impact on them in particular? So we conclude a final set of comments on your portrayal of national security. And the one question for you would be, what are the implications of new security alliances, and whether your paper addresses those or how your analysis would address those? So you certainly have such an agile framework that you could imagine that these new security alliances could be incorporated. I'm thinking here of the Australia, UK, US military partnership that was just announced, the EU strategy for cooperation in the Indo-Pacific. And so your paper does talk about bilateral and plurilateral rules on national security issues, but you seem to have in mind trade arrangements that are bilateral and plurilateral. So for example, the regional comprehensive economic partnerships provision that national security exceptions could include measures taken to protect critical public infrastructure, or the USMCA provision on national security that's more open-ended than GATT Article 21. So these are bilateral and plurilateral arrangements that they're trade agreements. So they're maybe different than these security alliances. Can the trade regime assimilate these types of bilateral and plurilateral security rather than trade arrangements? And if so, how? So you envision this sort of world where we're kind of moving around between plurilateral arrangements that are developing jurisprudence. We're moving back into the multilateral trade regime. What about these security alliances that don't strictly fall within the umbrella of international trade law? Would this be another form of lex specialis in the way that the WTO has to deal with multilateral environmental agreements or other forms of agreements, and just trying to figure out that interface? Or how would they relate? And this brings me back, and I'll conclude with this. I think a very critical insight that your paper has and generates that has a lot of power to it, that you have different exceptions in international trade law for economics, national security, and social policy that really have different parameters. And you envision a very sort of balancing and pragmatic approach, but we could imagine a much more critical approach that would assert that these are ultimately incommensurable. And it's there's frightening implications. So you note right at the end of the paper, you have Carl Schmitt in a footnote, and you sort of envision a permanent state of exception to multilateral rules, or the replacement of multilateral trade rules with a securitization of the global order. You're a move towards rather than international trade law absorbing national security. It would be national security that's absorbing trade rules. And the proliferation of these kinds of plurilateral security alliances could be interpreted as suggesting a move in that direction. How would you assimilate them back into the multilateral trade regime? So the paper has this beautiful sensibility, I think, critically aware, but also pragmatic and ultimately hopeful. And I'd love to hear more about the prospects that trade multilateralism rather than security plurilateralism will prevail.
Yeah.
I'll stop there.
Thanks, Chantal. That's a lot. So I'll do my best, maybe I guess one by one. And so we'll start with climate change. To me, well, climate change, how it's going, in particular, sort of the mechanisms being contemplated, particularly in Europe right now, for a border tax adjustment based on the carbon intensity of production. That's, is that legal under current WTO rules? And there's, as you noted, there's a lot of technical analysis of this, and it's going to be very complicated, particularly because it's actually so difficult to implement, to calculate, for example, what's the carbon intensity of a particular product, particularly where you have global supply chains involving, multiple components produced in multiple different countries and so forth. And so it's a major challenge of our time. I think then the way to start thinking about it is, the way I think about interpretation is that interpretation is basically a struggle over the meaning of the text. There's no one way to interpret that text, and that the governing principles of how we think about a text are going to have major implications for how we interpret it. So my own view is, as many others, that one can interpret WTO text easily and should interpret them to accommodate, unilateral measures. My second view is, that unilateral measures actually are going to be essential. I simply, given the time that we have before us and the major existential challenge of climate change, that this is a rule for, in a sense, strategic unilateralism. But it's got to be unilateralism then, which is linked to the principle of the article, which is subject to multilateral oversight. Otherwise, clearly, there's going to be all sorts of pressures to abuse the use of exceptions to favor national industries or so forth, which will simply trigger new trade rules and make everybody worse off. So I'm big supporter of what the European Union is doing. I wish the United States and Biden administration or some within the Senate talking about this. I think it's necessary for the United States to step forward, but we know the difficult domestic politics on this issue. But unilateralism can sort of change incentives, can change domestic politics if one thinks about sort of the transnational linkages between what's done unilaterally, and it also can change incentives for pushing forth sort of more regional, plurilateral, and potential global system with respect to addressing the price of the negative price of putting all the carbon, methane, and so forth into the atmosphere. So I think it's necessary. I think it's actually under existing WTO jurisprudence. I think it's actually, this is an easier area. I think one thing that Rob Howes at NYU and others have pointed out is that the WTO appellate body, for all the critiques of it, actually interpreted WTO rules to provide for a much greater space for addressing, environmental and animal welfare and other concerns. And so we have this jurisprudence, which basically says if you have a legitimate regulatory initiative objective, such as climate change, one that affects a global commons, such as climate change, and one that has direct implications for you and your citizens, climate change, then you can take, you're completely free to adopt those measures so long as they're not unjustifiably discriminatory. And it's so interesting, that's not only so long as they're discriminatory, but so as far as they're unjustifiably discriminatory. So there's a lot of space in there to apply climate change measures. And I think that it fits easily within the premise of the article. I simply focus more on labor and workers because I think we have no jurisprudence on this. And there's a lot more resistance on this, and particularly with respect to developing countries, which maybe we'll turn to in the conversation, but because of the implications for them. But my basic answer is yes, this is an example where unilateralism within which is non-discriminatory and proportionate to the concern is essential, but it should be governed under multilateral rules and subject to scrutiny. So that it's not abused. But in the interpretation of that, there's got to be an understanding of the need for policy space in light of the legitimate objective, which is quite obvious given what just took place the last couple of days in Glasgow of the challenge of climate change of our time. Is that good enough for, should I move to the second question?
Absolutely.
Okay.
And again, please feel free to answer none of these. Or any of them.
I'm glad to address each one, but also I just open up the possibility for you, Chantal, if you want to jump back in and ask, a follow-up question on each of your questions, because each of your questions are so important. And of course, you have a lot to say on these as well. So I am always wary of taking the position as if I have an answer, as opposed to a dialogue where I learn so much from you and others. And that really brings me to the second question, which I welcome your interventions, because it is obviously inequality is a challenge of our time. But as your question was based on identity-based forms of inequality. I mean, Professor Jose Alvarez has a wonderful article for a symposium I'm doing with my wife, Michelle Goodwin, here at Irvine, on sort of the racial disparities of COVID and what should be done about it, including in terms of reparations for those racial disparities, which are horrendous and tragic. And so we see this is an area basically which is, to be quite honest, it's an important area which I'm clearly delving into now by organizing these symposia, but I'm learning a lot in the process. And so I'm processing a lot. The idea, I mean, clearly gender and race are both national issues, but they're clearly transnational issues. I honestly don't, I mean, Justin Trudeau and others, right, have been trying to put the, gender and within the trade regime, but they've been doing it in a way which is, more sort of a form of soft law. We should, and soft law can be quite powerful, as I've written elsewhere. So we shouldn't just be thinking about this in hard law, because it says these are norms. We should create a better understanding, an empirical understanding of sort of disparities that exist. We should create a forum, a deliberative forum, to try to address these disparities. And we could think about peer review processes where we subject each other to critique. Right now, much of this, of course, can be done in the United Nations outside of the WTO regime. And so the question will also be, what's the relationship of these different regimes? But clearly, on the trade area, it's the issue, what are the implications, right, of trading rules for these concerns? I don't have much more to offer right now than that there's a place to create. I mean, I think actually an underappreciated aspect of the WTO traditionally was its committee-based system, its sort of deliberative bodies. And that, of course, also has been under threat and undermined, given that it was just one of three pillars, the others being negotiation and dispute settlement. And they're all under sort of mutual pressure to just be taken much less seriously. But I think there's a role for multiple forum. And within the WTO itself, it has a system of other international organizations having observer status. So one could imagine, even if other international organizations take a primary role, they would have something to say, including within the International Labor Organization, which has had less close of a relationship to the WTO, although they have done some joint work together with respect to gender race implications of trade. If you have more to sort of either push back on or to add or to complement, I really welcome that, but more just as a thinking exercise, because obviously it's something which traditional trade regime has simply said, this is not our issue. It clearly major issues of our time that, we just can't put blinders on.
Yeah, no, I agree with you. We're being sort of asked to respond to the moment, in which unexpectedly, space has been created in political discourse for these questions. And so I think it's a new horizon for many of us.
Yeah. The next issue was on developing countries, of course, which is, I love the question because it just tells us, shows how much things have changed in many ways for the worse, right? And so I just give when I started researching the book and going to Geneva, the book involved, hundreds of interviews, right? And different capitals and different embassies and the secretariat and NGOs, people and other international organizations and so forth. And the real focus was on developing countries, right? Because the big challenge was that power is simply replaced by other forms of power. So sort of the bargaining power is replaced by sort of what I call, legal capacity, sort of the ability to rule through rules, which is a quote from John Eikenberry, political scientist at Princeton, basically saying this is a good thing, right? This is what the United States and powerful countries should do, is to rule through rules. But of course, for developing countries, sort of like, well, we got these rules, what can we do so that actually the rules are not used simply to discipline us in both a material and a Foucaultian sense, but also how can we use these rules for our own development purposes? And that's where, and so a lot of the research on the dispute settlement system was about, well, how can we make this available, right? Given its costs, and given the relatively smaller trading volumes, and giving the system of remedies, which is based on retaliation, which favors countries with large markets, such as the United States. How can we rethink it, re-envision this? And so I have a joint course with students in Singapore on trade investment law. And they're supposed to present a project next week. And part of it was, how to reform the WTO dispute settlement system. And of course, they put in everything with respect to these countries, but then also the US-China conflict. Part of it was, it's like, well, in 20 minutes, you can't cover both, right? And the salient issue of the day is, the whole system has now collapsed, right? And so we need to address US concerns, and we need to sort of move, what is the appropriate response given what the United States has done to this dispute system? Of course, once we move into that frame, right, of what the problem is, developing countries completely drop out, right? So I think we should just take note of this, and this sort of links to a question down the line from you, which is, yes, this sort of refocus of US-China relationships means that the whole idea of a Doha development round, or the whole idea of how could we, enhance the ability of developing countries to actually have their voices heard, or how could we have enhance the voices of others within developing countries who are not well represented by their own governments, have their voices heard. These are just simply not the existential concerns right now of debate, because the existential concerns are the rise of China and governing the China-US relationship. There's nothing in Washington, D.C. or in Brussels right now, or in Beijing, right, which is anything except, how to look good vis-a-vis developing countries, but not actually, how to systemically, address their concerns within the world trading system, right? So that's a major shift, and there are, so part of my concern also is that the current Biden administration's policy, backed up by much mainstream academic opinion, is that we need new WTO rules to rein in China, otherwise the whole system's going to collapse. Is, of course, those rules are going to discipline not only China but all developing countries, and so and their role is to basically cut off policy choices for those countries, be it with respect to the use of joint ventures, technology transfer provisions as part of those joint ventures, be it different forms of the role of the state within the economy, the role of subsidies and so forth, industrial policy. And so I just think that it's a category mistake to think that we're going to use this existential moment of the challenges with China, that the only way we're going to relaunch a binding neutral dispute settlement system is to create new WTO rules constraining the state. It's not good for developing countries. Maybe for many people, they think it is, right? And my argument is fine. You can go tell them that they'd be better off with this type of domestic policy, but the idea of creating an international rule that takes that choice away from them is mistaken. Because you don't know, I don't know, right? Nobody knows, right? If anything, China's, historic, rapid economic growth over the last 2 decades, and not engaging in, quote, shock therapy like Russia and other countries, but rather taking a much more gradual approach and creating markets within the Chinese economy, it seemed to fare empirically much better than what happened in Russia. And so maybe we should be a bit wary about not only prescripting what other countries should do, but actually binding what they're able to do through new international rules. Do they benefit or not from this relationship? From this new tensions. Clearly, to the extent that you have a Belt and Road Initiative and the U.S. response is we're going to create our, put more funding into this for our own, there's possibilities that they can benefit. And so that would be the silver lining. But I think most of them, one, they also feel that the uncertainty that's been created through the trading system is also quite detrimental. And some will benefit, such as he mentioned, Vietnam, as firms are pressured to source their products not outside of China because of the potential for high tariffs on China. But I think overall they lose in 2 ways. One, their voices are drowned out, so simply their major concerns are not being addressed. And 2, just the potential radical uncertainty of that is created, where you can suddenly there's the ability to put pressure on them by China unilaterally and by the United States unilaterally, and because sort of the normative constraint of having multilateral rules is simply dissipated. I think they're back in a power-based situation. They're much worse off.
Right. There's the sort of contrary view that developing country governments could utilize that bipolar tension in a kind of new version of a non-aligned movement, and that the uncertainty will actually be beneficial because it means that strategically governments can play off one major power against the other, right? It sounds like you don't subscribe to that idea.
I mean, I've actually, written an op-ed, said this is a potential silver lining. You make the most of a bad. In other words, one can try to be optimistic, right, based in the situation we now confront, right? And so, yes, I think there's a silver lining potentially, and one should try to harness that, and maybe one should start thinking in those terms. But my overall view is no. I think most countries actually don't feel that they're better off, right, through returning to a power-based system, even if they can, quote, try to play off the two sides. But it's an empirical question, it's more, ultimately, one has one different intuitive senses. And let's turn to the last one, and I think we got a little bit more time, right? The national security frame, drowning out everything, and the rise of new alliances, and what is this? What's this relationship to the trading system? Clearly this is the approach of the Biden administration, which is generally applauded by most experts in the United States in the terms of the inside the Beltway, because of course it seems a lot more strategic than just sort of going off after the entire world, right? And threatening everybody with tariffs, right? And so how does this sort of fit into both to the trading system generally and sort of my overall framework? Is that the fair way to sort of restate the question? I mean, one, national security, once you raise the issue of national security, you're basically, it's another way of saying this is an assertion of state sovereignty. Mm-hmm. It's basically an assertion that there's no role for multilateral rules. I mean, one way to think about this, and Harlan Cohen wrote a nice piece on this down from the University of Georgia. And so it is, and of course, but there's another way of thinking about national security, which is when you're talking about the alliances, but not only national alliances, national security also, of course, involves arms control. And these involve negotiations. They involve, verification systems for enforcement and so forth. Danny Roderick has teamed up, while I was writing this actually, with Steve Wald at the Kennedy School. And Steve Wald is a realist, and in terms of international relations theory as opposed to legal realism. And their vision is different than this paper, right? And their vision may be more accurate because this paper is more of a normative paper than it is, like this is empirically going to describe what the future is. It's rather saying this would be a better future. That's the purpose of the paper. But they're basically arguing, trade is becoming a form of arms control, right? What are the principles? Now arms control also involves principles, right? Trust and verify, so forth, and involves treaties, involves bilateral treaties, some multilateral. And so this is one vision of this, so that even though you have these, new alliances and so forth, you're still going to have to encounter, the other side, China, Russia, whoever. That's just the nature of it. I hope that this, and of course, in that vision, there's no binding third-party dispute settlement and arms control treaties, right? It's all like the phase one US-China deal. If that's the future, I think my own argument in the article is that actually will reduce national security in the United States, not enhance it. It will, because everything's going to be then viewed in security terms. There's actually having these trading links and having cultural links and not viewing, national security tends to view all countries as sort of billiard balls, right? The China is this monolithic thing, and the US is this monolithic thing, and the alliance with Australia and UK, you know, but these are complex societies, right? It's good for us to understand these societies as complex societies. There's reform, there's the whole economic debates and trade policy debates in China are very deliberative, right? And clearly, you know, the Xi government is it's an authoritarian government, but that doesn't mean that there's not intense discussions over policy within China. And same within the United States, obviously. And so there's a risk of securitization of everything. There's also a risk that I think we saw in the interwar period, to go back to my opening turn, which is the rise of trading blocs, right? You're either with us, you're against us. And so China's going to create its trading blocs, we create our trading blocs. And that didn't have a very good outcome in the middle of the last century. It also enhanced the sense of in Japan at that time of insecurity, that it could be cut off from vital natural resources and so forth, which made Japan feel to defend its own security interests, it had to be more aggressive within the region. I think that this would not be a very good national security policy, much less a trade policy.
Yeah. Well, thank you so much for those really thoughtful and insightful responses. And I'm sorry that I pummeled you with so many questions and caused us to run through almost our entire time. But we do have a few. But thank you, really helpful, and I look forward to continuing the conversation.
Likewise, Chantal. Likewise.
We do have a few moments for other questions or comments. I have a question from the floor, and I think I just read this from Carlos Perez Chao, that President Trump requested Mexico not to engage in contracts with China on strategic areas. And do you know if the current administration has the same restriction? NAFTA included in the USMCA the prohibition for Mexico and Canada to enter into a free trade agreement with any central economic planning country. So just your thoughts on this. Is this a continuing priority, and should it be, or how does it fit into your analysis?
Yeah, so this is, these represent the sort of U.S. trying to divide the world into blocks, and Mexico's got to be in our block, right? Being our neighbor in Canada and so forth. So I think that if anything, the Biden administration will continue this, is continuing this. People in Mexico would know much better than me, so I'm all ears if anybody wants to chip in on this. I mean, obviously, which I'm not the first to raise this on the second point, the provision within the USMCA and not to enter into, trade agreements with a centrally planned country. And of course, what the Trump administration immediately did was enter into the phase one deal with China, which in a sense would, some would then quip, well, should Mexico and China and Canada now leave the USMCA because the US has violated this provision? I think it's US, that sort of type of gross provisions, right? I just think is a mistake. It's, and of course it's a soft law provision, to the extent that Mexico and Canada were, let's say China was to enter into the CPTPP, right? Which it joined, right? Well, I guess it would Canada, let's say Canada and Mexico, right? Then, are also part of this. Let's say then the Biden administration finally wants to join it as well, right? I mean, what happens to a provision like this? It becomes sort of meaningless. So I don't find that type of provision. It was symbolic, I think, more than anything. The other, of course, is real, right? I mean, both of them are real, I guess. This is obviously just so broad and enter into a trade agreement with China. For Mexico, and I think, there's also is a provision, I should just say, that they were putting in there as sort of a template to try to also use for other countries. But, there's a problem because, Australia already is in a trade agreement with China called a massive one called RCEP, much less bilateral agreements and so forth. And so other countries are not going to agree to this. And I think it's mistaken. On the, constraints with Mexico and in strategic areas of using Chinese products. This could be viewed as a form of a predatory policy under bucket one of the principles, right? Purely economically, right? It's hard to say, it's basically telling a third country, right, that they can't use certain Chinese products, right? Even if those products are cheaper and more efficient. And Mexico, is a middle income country. It doesn't have the wealth. And if you start doing this, say, with respect to African countries, you're basically, making telecommunication systems and others much more expensive for them. So it is problematic, highly problematic and the question is it proportionate to the security risk? Mexico is under a lot of pressure just because it's a smaller country and it depends so much on the US market for its economy. It's, I don't know the extent to this going beyond Huawei. I mean, Huawei, obviously, with respect to basic infrastructure, communications infrastructures, which are also used, with the United States, you can start to say, well, these infrastructures also are linked to US communications networks. So there's a closer national security tie, but it's, to me, this is certainly goes to an issue of is this proportionate? And the answer is, well, it depends on how you define national security, right? If you define it in a very broad way, such a broad way as we want to destroy these Chinese companies, we want to basically, destroy their markets, then that's a form of national security, basically of geopolitical rivalry. But obviously, China is going to respond in a certain way, just like Japan responded in the interwar period. And I'm wary of these types of policies. But my sense is that the National Security Council and the Biden administration is likely carrying on these policies and these types of discussions. Yeah.
Fantastic. Well, we have a few moments left. I do have a message from Jose that he had a couple of questions that if there was time, he could pose to you, Greg. And I don't know when also you want us to wrap up. I think we have another 6 minutes, but Jose, can I call on you?
Sure, and it's only 6 minutes, so I'll probably restrict myself to just one. So I, as the organizer of this, I can anticipate something in the criticisms, which is here we're talking about US, China, and I have two, albeit eminent, US trade people. Where's China? So one is to assure our audience that December marks the 20th anniversary of China's accession to the WTO, and our last two speakers will address that. And one of them is a major trade scholar who I will pose your article as one of the things for him to comment on. But I guess I want to put, Greg, give you the chance, which is, I have heard that this trade policy working group and the joint statement did not have much pickup on the Chinese side of things, and that in fact, it's not at all clear that China would buy into what seems from our perspective as a rational, balanced approach to how to do this. So what if I had a Chinese commentator, what do you think that person would say to object to how you analyze things?
Yeah, so great. Thanks, Jose. It's a great question. There is, I will say, right, in the conclusion to the article, I say frontally in one sentence that, I am I'm a white male American writing from someone who lives and works in the United States. And so we're all positioned where we write. And I was asked earlier, in terms of just comments on the article, sort of a variant of this question. And I think the best response is, well, one, if you were to ask someone from China, I'd be wary of saying they're going to be, quote, the Chinese response, right? If it's going to be the Chinese response, then that's sort of, it becomes very boring because it becomes very bureaucratic and officious and so forth. It'd be as if you had an official Biden administration response where, right before giving the response, the speaker was told, yes, but you can't say A, B, C, or D, right? Because we have ongoing negotiations on these issues, right? So I say that just because it depends on who you would ask the question to, right? There were obviously signatories to the joint statement. That's what made it a joint statement. And so they represented views within China, and they were actually some major, academic figures within China. And so they're more like, so I think part of the response is twofold, right? What I tried to do in this article. One, just admit, or threefold. One, admit, that yes, this is writing from within the US context. So this audience is predominantly going to be a US audience, and pushing back against certain tendencies in terms of policy promotion in the United States. If anything, the concern, I think, would be that I would be viewed with this article as a China dove, and thus consequently completely irrelevant for any discussion within the United States. That just the opposite sort of fear of having a bureaucratic member of China giving an official response. The second response is that, well, the joint statement was a joint statement. It was an effort, right, amongst those within China and the United States to say, can we at least come up with a common approach? Maybe our governments can't, right? Maybe not. But let's try to bring people who live and reside in both countries to see if we can come up with principles, right? So that's number two. Number three is our citations, not just to Western authors in this article, but also to Chinese. And so I tried to do that as well to provide support. Some of those Chinese scholars actually are probably more on the neoliberal dimension than I am. And so, I mean, you can see this with respect to China's bid to join the CPTPP, China's defense of multilateralism, China joining 121 other WTO members to call for the relaunching of the WTO dispute settlement system, and so forth. So I'd be very interested in having a Chinese colleague respond to this. I am sure that in this article, given that I'm writing in the American Journal of International Law, as an American with a predominantly American audience, with the United States being basically the power which has destroyed the current system, and responding to this moment, right? That yes, it has a focus on US policy as opposed to Chinese policy. But I think that my intuition would be that many Chinese would find that this particular approach, I mean, I think they would have no trouble. Let me just be even more nuanced to predict their response. I think they'd have no trouble with the economic section. I think they'd have no trouble with the national security section. I think they would have trouble with the social policy section. As I think we didn't get to this, some developing countries would, simply because it's more likely these sort of these forms of discipline would be used, they would fear, against their country as opposed to against the United States and Europe. And so fair enough, but that would open up a whole different discussion, and we're out of time.
Well, thank you. I think you did a good job of possibly anticipating my question, and it sounded like it was written on the spot. It was so elegant. But thank you both for spending so much time with us, and Chantal for looking so carefully at this piece, which I think will be influential one way or another in the discussion. And you're both, of course, welcome back anytime when you have new work that will be relevant to our audience. And thank you all for joining us. And of course, some of you may actually be watching this at a different time when it's recorded and at a more appropriate time than midnight or 3 o'clock in the morning, wherever you are. But thank you all, both Greg and Chantal. Bye-bye.